Hello everyone, my name is Dabrowska and I would like to invite you to my lecture on the role of the German National Parliament in the EU. And for this presentation, I have chosen a legal perspective to provide some insights into the legal frameworks that form the foundation of the German Parliament's participation. And before we examine the regulations of the basic law, which is the constitution of Germany, I would like to offer an introduction to the bicameral system of the German Parliament. And Germany, as you may know, is a federal state with one national parliament, the Bundestag. And due to its federal structure, Germany has 16 regional parliaments with its legislative competences. And this structure leads to the creation of the second chamber of the parliament, the Bundesrat, which is composed of representatives from the 16 federal states, state governments. And these representatives are appointed by the members of their federal state governments in the Länder. So this is what it's called in Germany. So in its ruling on the Treaty of Lisbon, the German Federal Court, Constitutional Court outlined the concept of the responsibility for integration of the national parliament. And this framework is based on Article 23 of the Basic Law. And its parliament-friendly interpretation is largely thanks to the German Federal Constitutional Court. And the Article 23 was edited in 1992 in connection with the ratification of the Maastricht Treaty on the European Union, following the Treaty of Lisbon, this article established a foundation for the crucial goal of European integration in terms of state policy and treaty law. And it compensates for the loss of competences that comes with the advancing European integration and reflects the understanding that EU matters can no longer be treated as traditional foreign affairs, and instead they are a part of the domestic law and policy. So the first paragraph defines the unification of Europe as a national objective, addressing the structure of the European Union and the transfer of sovereign rights. And the German Federal Constitutional Court refers to this as a European law friendliness. However, there are limits to the integration mandate, such as preservation of Germany's own state identity, which would be jeopardized by joining a federal state. According to the German Federal Constitutional Court, democratic principles are upheld only if the legislative bodies, the Bundestag and the Bundesrat, are granted decisive participation in all expansions and transfers of competence, especially moving from unanimity to majority decisions as outlined in the Treaty of Lisbon, without requiring an amendment to the treaty. And in the court's view, the national parliament plays a central role in providing democratic legitimacy to the EU, and this legitimacy must not derive exclusively from the European people. Currently, the Union's core democratic legitimacy comes from the parliaments of the member states. And the federal government may only transfer sovereign rights in order to participate in EU through formal federal law, which requires the approval of the Bundesrat, which is the second chamber. And this should help to compensate for the loss of competences by the federal states that are represented through the Bundesrat in the integration process. And in practice, laws related to the Maastricht, Amsterdam, and Nice treaties, as well as the Treaty of Lisbon, were ratified by a 2/3 majority in both the Bundestag and Bundesrat. And the same applies to the European Stability Mechanism Treaty and the Fiscal Compact. And any violation of that can be challenged by any citizen in Germany through a constitutional complaint. And furthermore, in this paragraph, there is an integration barrier, and it's the prohibition on actions beyond the EU legal authority, and also the prohibition of the Federal Republic to completely relinquish its sovereignty or losing its status as a state. And then next paragraph is a consequence of the Lisbon Treaty that aimed to strengthen the role of national parliaments. And in this context, the Bundestag and the Bundesrat has the right to bring an action before the Court of Justice of the European Union to challenge a legislative act. So basically, the yellow card mechanism. And this action is outlined here, and it's structured as a majority right to the national parliament. Paragraph 2 regulates the participation of the Bundestag and the Bundesrat in the EU affairs, and the right of participation established here are intended to partially compensate for the loss of policymaking influence. And the federal states participate through the Bundesrat, as already mentioned. And the foundation of the participation is a general right to inform or to be informed through the government. And the matters concerning the EU are to be interpreted broadly, and the information must be provided at the time that enables the parliament to exert effective influence on the government's decision-making process. And the Bundestag and the Bundesrat must not be reduced to the role of just an observer. And according to this paragraph, the federal government shall notify the Bundestag and the Bundesrat of such matters comprehensively and as early as possible. And comprehensive means that the federal government is required to provide both federal bodies with all information accessible, which relates to the preparation, exercise, and fulfillment of the EU competences, powers, and objectives. And the duty to provide information only finds its limits within the core area of the federal government's executive responsibility. And however, even if this limitation no longer applies once the federal government has presented the results of its decision-making process to the public or has entered into a coordination process with third parties. So the next paragraph concerns the most important form of participation of the Bundestag under constitutional law in accordance with the paragraph 2, namely the submission of opinions prior to EU legislative acts. And the federal government is required to give the Bundestag the opportunity to comment. And this necessitates that the Bundestag has to be informed in a timely manner so it can form its own opinion. Also ensuring that that any opinion submitted by the Bundestag can be still taken into consideration by the government. And this information provided relates to all documents of the legislative process, and the government must consider any opinion submitted, meaning it must incorporate it into its decision-making process. But in practice, the Bundestag does not often make use of this opportunity to comment. Paragraph 4 governs the fundamental participation of the Bundesrat of the second chamber, and its duty, the duties of the government are similar to those of the Bundestag. Also, they need to provide information to the Bundesrat, and And the participation of the Bundesrat is not limited to legislative acts, but is required under two alternative conditions. First is if the Bundesrat would be involved in a corresponding domestic measure, and second, if the federal states would have domestic responsibility. And the next paragraph outlines how the Bundesrat's opinion are to be considered, and it differentiates the weight of these opinions depending on the subject matter. And there are three areas that are distinguished. The first one is the area of federal legislation, the area focused on the legislative competence of the federal states, and the area concerning the exclusive legislative competence of the federal states. And if the matter pertains federal legislation, the Bundesrat opinion is only to be taken into account. However, when the matter concerns the legislative powers of the federal states, or the organization of federal state authorities, or the administrative procedures of federal states authorities, the federal government must give the Bundesrat's opinion a decisive consideration, ensuring that the Bundesrat has a significant influence on the outcome. And in practice, the Bundesrat exercises its right to comment more frequently than the Bundestag. So lastly, the last paragraph regulates the participation of the Bundesrat, more the participation of the federal states. And it's primarily refers to the conduct of negotiations in the EU Council, which must be transferred to a representative of the federal states that is appointed by the Bundesrat. If the focus of the exclusive legislative powers of the federal states in areas such as school education, culture, or broadcasting. And this exercise is limited by the involvement of the federal government and the necessary coordination with it. So to summarize, the regulation has a threefold objective. First, it serves the domestic legal basis for EU membership. Second, it aims to strengthen the democratic legitimacy of the EU by ensuring that the Bundestag plays a central role in European legislation through its involvement in the decision-making process. And lastly, it compensates for the loss of competencies experienced by the federal states. While this framework positions the Bundestag as a co-designer of German European policy, it also places an obligation to the Bundestag and to the Bundesrat to actively fulfill its responsibility for integration. And in this graphic, we see that there are that there are differences in the participation of the Bundestag and the Bundesrat. While the opinion of the Bundestag must be only taken into account, the Bundesrat has a graduated rights of participation in European legislation. And it could be discussed whether the Article 23 should be amended so that in areas particularly sensitive in terms of domestic policy, the opinion of Bundestag as well as now of the Bundesrat should be considered by the federal government, allowing the Bundestag to have more fundamentally binding effect. And this can be one conclusion of this presentation. Another important conclusion to take into account is that Germany's federal system is built on the principle of individual states maintaining legislative autonomy, allowing them to respond to the diverse needs of their populations. However, the states theoretically retain their competences. In practice, the unification of law within the European Union forces them into compromises that diminish this autonomy, because through the Bundesrat, the states are required to act as a single body, a single unified body, when participating in EU affairs. and that could result in a loss of consideration for the unique legislative needs of each state. And this is a process of further centralization, and this has its advantages, but also a lot of disadvantages, because it limits the right of the states to tailor legislations and the local democratic representation. And yes, this is my conclusion. Thank you for your attention. Maybe about the about the discussion for the, I don't know if you have time or maybe later when the Q&A is.
As you wish. We have time now to shortly refer to it, and maybe at the Q&A we can come back to it on the basis of what you have said.
Okay, so I can just give like an idea what the conference was about, or the conclusion the experts drafted was that the European Union is like a ship that is not fully built and completed, and everybody on the ship is working on it, and in different areas, why the ship is still swimming in the sea, and everybody is trying to maintain the ship. So that was the idea the experts gave us. So yeah,
very metaphorical.
Yes.
Okay.
Okay.
Maybe we can come back to it.
Yeah. Thank you for your attention.